Hey guys, Chicago injury lawyer Scott DeSalvo here, and in today's video I'm going to answer the question, what do I need to know if I'm going back to work light duty in my work injury case? Okay, so important question to know. This probably comes up in at least half of my workers' comp cases, and it's just so important to know what to do and what not to do and how it works, right? I will say that my information is based on how things work in the state of Illinois. In workers' comp is what attorneys call a creature of statute. That means each state passed its own workers' comp law. Way back when, 100+ years ago, when they first passed these laws, they were all pretty much similar state to state. But as time has gone by, they've gotten modified, right? So the legislatures in various states. So things in your state, if you're not in Illinois, might be different, and it's important for you to get a consultation. So, if you have questions about this, please do not hesitate. Give me a call, whether you're in Illinois or out of Illinois, at 312-500-4500, 312-500-4500. Free call, free consultation, no obligation. So call anytime, night or day. So how does it work? So in workers' comp, you have a right to be paid 2/3 of your salary or your average weekly wage. Whatever you usually make in a week, you're entitled to get paid 2/3 of that while you're off work with a doctor's note. Now, I call it a doctor's note. People, insurance adjusters and lawyers call it a work restriction. I just call it a doctor's note because that's what it really is. I don't like fancy language, but it's basically just something from the doctor saying there's only three possibilities. One is you're okay and you can go back to your job full duty. The second one is you can't work at all. You're messed up. You are unable to go work in any capacity, and the doctor wants you to rest and heal. Third is the doctor believes that you can do some work with a restriction, meaning if you have a leg injury, no standing. If you have an arm injury, no lifting over 5 pounds, or no repetitive movement with the arms, right? Whatever it is, right? And the restriction should match what your problem is, right? So if you get a doctor's note that doesn't match your restriction, you got a problem. You better go back to the doctor and get a restriction that's appropriate for what's wrong with you. What do I mean? Well, I talked to a guy recently who had a no lifting over 10 pounds restriction from the doctor, but he had a leg injury. He had a broken leg. So according to this work restriction, the guy could stand all day on a broken leg as long as he wasn't lifting more than 10 pounds. So that's obviously not going to work. If you get a bad work restriction, you got to go back to the doctor and get an appropriate one. And if your doctor won't help you, switch doctors. Like, at the end of the day, the treating doctor, the doctor you choose to treat or do surgery on you, is so important in the workers' comp case. If you get a jerk or a guy who's asleep at the wheel, it makes proving your case basically impossible. So you got to have a doctor who's on your side, or at least neutral, who will listen to you when there's a problem, right? So what was I saying? See, this is what happens when you don't have enough coffee. You get up, you get ready, you start driving into work, you don't have enough coffee, your brain doesn't work. Light duty, right? So those are the three possibilities: full return to work, light duty, or completely stay off work, right? So what happens if you have a return to work and the restriction is appropriate to what your problem is? Well, this is what I tell people. I tell people that if you get a light duty or restricted duty note, it is always better to go back to work and try to do the work, okay? Now, what you need to understand is if you have a restricted modified duty or restricted duty or a light duty doctor's note, your company has two choices. The first choice is they can accommodate the restriction, meaning a lot of times they're going to put you at a desk and make you sit there 8 hours a day. Can they do it? Yep, they can do it. Is it kind of a BS thing when you're not really being productive for them? Yes, it's a BS thing. Do I think it's fair? No, I don't think it's fair. I think it's ridiculous. Unfortunately, companies can do it, and you have to go. And if you go, then you get paid, right? What if Their second option is don't pay, or say, no, there's literally nothing here for him to do or her to do that's productive. Then, as long as you have that restriction, you stay at home and you get paid TTD, which in Illinois is 2/3 of your pay. So what are your responsibilities? Well, if you have a light duty note, you ought to get that light duty note to your lawyer right away, and you need to send it to the company and to the insurance adjuster on your claim file. Every time, I tell people, every time you go to the doctor, you see the doctor, even if it's telehealth over the phone or over the internet, get a fresh off work note. Because if you don't, and if the insurance company and or your employer doesn't get a fresh off work note, because they track when you're going to the doctor. If you don't get a fresh off work note or a light duty note, they're going to assume you got a full duty work release and you're just not showing up at work, right? So don't do that. You got to send it to them. And as long as you do that, you're protecting themselves. Now, is that a guarantee that they're going to pay you no matter what? No. I've had a lot of cases where there's a bureaucratic or a paperwork glitch, administrative glitch, some kind of problem with their payroll system where you get bounced off the payroll, or the insurance company had the wrong address or sent it to the wrong location. That happens all the time. And my office is able to clear it up with several phone calls, and we're aggressive about it, right? When somebody's not getting paid, in my office, it's a high priority. I want to know what the problem is. And then once we know what the problem is, I would say 70-75% of the time I can fix it. Like, I'll go get the documents they need or whatever it is they need. But you can avoid interruptions in your TTD by making sure you have that off work note, that light duty note, whatever it is, right? Doesn't mean that they won't hire a doctor to look at your medical records and say, no, this guy can go back to work full duty. Now, when you have a situation like that, can they cut you off? Yes, they can cut you off. Can I often or usually fix the situation? Yeah, but if they dig their heels in, our only option is to go in front of court. Now, I'm going to tell you and be honest, under the best of times, you're looking at 6 or 8 weeks, sometimes less, but 6 or 8 weeks before we can get into a judge. That's just the way the system is designed, and I'm telling you, with the lockdowns and the disruption to the courts and the commission, that time is still more or less true. So they've done a great job in that regard, but it could be longer. The other thing is, arbitrators, judges in workers' comp cases are constantly coming in and going out. So, if we have to go to court, you might have a period of time where, where it's tough, where the money's not coming in. That's why I'm telling you, it's a really good idea to just play by the rules. If you get a light duty note from anybody, go to work and try to do it. If you're not able to do it, return to your doctor, explain what they were asking you to do. Now, if you go to work and your employer doesn't accommodate your restriction, you should call your lawyer, you should call the insurance company, you should go to your doctor, explain to your doctor what they're asking you to do and how it's outside your restriction, and then your doctor will write you a note specifically saying that you're not allowed to do that, and if that's what they want you to do, then you should stay off work, okay? So that's, in a nutshell, without going on for a half hour or an hour or 2 hours, in a nutshell, that's how it works, and that's what you need to know if you're returning to work light duty. So you have some responsibilities, they have responsibilities, but what I always tell people is always keep in mind that acting reasonably and making it clear to the judge that you are ready, willing, and able to go to work when you're physically able to, and that you want to return to work, that impresses the judges, and it can weigh things in your favor. That's why I say if you get a modified work duty note, definitely try to get back to work even if you don't feel like it. It's going to help your case and avoid a lot of frustration for you in the future. If you or a loved one are frustrated, worried, or have any kind of injury case question and you want it answered for free with no obligation, give me a call at 312-500-4500. Really appreciate it. If you have anyone to refer to me, you can just call us at that same number and let us know you want to refer a case. 312-500-4500. That phone gets answered 24 hours a day, 7 days a week, 365 days a year. There is never a charge and there is no obligation. And I'm also very easy to talk to, I think. Hopefully you agree. And if you do agree and you enjoy my videos, please consider giving me a 5-star review on Google. I'll leave the link in the description. Really easy. You just cut and paste the link into your browser, click 5 stars and say a nice word or two, hit submit and you're done. It's literally takes you 5 or 10 seconds to do, but it would really mean a lot to me. It would really help me out a lot. And it would be a nice way to say thank you for the videos and the information I give to injured people. So if you do that, that's great. Of course, always I enjoy a subscribe or a like or a thumbs up. And if you do subscribe, hit the bell icon. Truly, I will tell you, the world is a crazy place. And, you know, you might get many opportunities to talk to a lawyer, or you may have none. Or you may have several jobs in your lifetime, or you may have one, or you may have none. But you definitely have one body and only one body, and that's why my whole law practice is focused on making sure I'm reducing the stress levels of people who've been injured and making sure that they're getting appropriate medical care and giving themselves the best chance to get better. And really, that's what my law practice is about. And then once all of that is lined up, my priority is making sure that the entire case and claims process in injury cases is smooth for you. So if there's anything I can do for you or your family, please feel free to give me a holler, 312-500-4500. God bless you and your family, and take care.